Counsel, you will have up to 15 minutes to present your argument. If you do, well, you don't need to reserve time for rebuttal in this instance. The arguments are, however, being recorded as usual, and we ask that you please introduce yourself, keep your voice up, remain behind the podium. You should not use the name of children or minors or victims during your argument, although you can refer to those folks by initials or terms like the child. The judges have read your briefs and are ready to proceed when you are. Counsel.
Judge Carr, Judge Sutton, Judge Stevenson. May it please this honorable court, I am Richard Kudachief. I am court-appointed counsel for my client, Lacy Bentley. So you're probably wondering, or we may wonder, why am I appealing a community control violation? I mean, this woman pled guilty, for heaven's sakes. She's guilty. Well, not so fast. Well, one of the reasons also I was asked to do this appeal, and second, she has a right to do that appeal. But I'm also here because the rules weren't followed on this case. It wasn't fair for Lacy, and I'm here to stand up for her. So this case provides an opportunity for this court to either further define, clarify, or at least in this case, provide opportunity for the trial court to understand, look, CCV, yeah, we tend to sometimes be quick on it, but notwithstanding, there are procedural requirements and safeguards that have to be met here. Lacy was not given, was not afforded basic due process. In other words, well, let's say, what did Lacy do? So let's look to the record, because there is not any answer in there as to what Lacy did to violate her probation. So why is the CCV important? You know, if you look at, as you have all done as judges below, we're going to look at CCVs to see if a person is going to be amenable to community control. So if you mess up on community control, well, that could be a problem in the future. Or, for example, if you have a federal case, it's another point. Well, let's see what else. Oh yeah, prison time, which is exactly what happened here. Now, I didn't make these rules, but this court did. We have precedent, as I've said in my brief. So this court has set procedural requirements and procedural rules. And here, the colloquy between my client and the court was insufficient. So we have Lacy pleading guilty on April 7th of 21 to possession of drugs, a felony of the third degree. That's a weight issue, not trafficking. There's nothing extraordinary that I'm aware of, certainly not in the record. It's a weight thing, not a sale. So a month later, in May of 2020, she's sentenced. And she's given a maximum of 36 months, but she was suspended, placed under a reserve, whatever you call it these days. And she was given 24 months community control. So my client is an addict. So what's the best thing for an addict? Rehabilitation. And we might say, well, jail's rehabilitation. She's probably not going to get any drugs there. But is that the correct sanction here? And I will get to that momentarily. No, it is not. So 3 weeks later, my client is now charged with a community control violation. 3 weeks later, you can hardly find out where a probation office is in 3 weeks. So I don't know, the record's devoid of what particularly that's all about. But she's claimed to have a violation of rule number 5 and rule number 6. Now what we don't have, there's nothing in the record, first of all, that she received these rules, because the government never presented any exhibits, let alone argument. There's nothing to indicate that she signed these rules, so there's no notice here. It's a problem with notice. There's no evidence she was given these rules.
Mr. Kuchief, how do we get around the fact that she did plead guilty, so that's one reason why we don't have a record of what was going on?
Well, Your Honor, I appreciate that question because I think that's a very important point. The reason she pled guilty, I do not know. Because if we look at the total record, here's what we don't know. We don't know what a potential sanction is. She was never advised that she had a right to have a hearing. She was never advised that she had a right to cross-examine. There was no foundation on a factual basis as to what my client violated. So I hear you talk when you say, well, she pled guilty, and that is a big concern for me.
Is there a case law that says she has to have her hearing right explained to her on a CCV case?
Absolutely.
Someone has to say, you have a right to a hearing, you can cross-examine. Is there a case law that specifically says she has that?
Well,
Duty to advise of that specifically?
this court certainly said so in State versus Lacy, also in State versus Phillips, as I cited in my brief. 2018 Ohio 2871 is the Lindsay case. And the reason that's for, so if you take back the process here and look at how it transpired, what did Lacy plead to doing wrong? That's why in most of my cases...
Are you saying the probation violation didn't explain issue? Violation 5, for instance, was not reporting. Violation 6 was using drugs and relapsing.
Yeah, exactly. And
So
more
you're saying
important,
when we look at the record, it's not going to be clear what that probation violation was?
Your Honor, if you look at the record, there's nothing that comes to my client as to what Rule 5 and Rule 6...
Let me ask this specifically. If I look at the community control violation that was filed in this case, does it have an issue 5 and issue 6 to explain an issue? One was relapsing and one was not reported.
Well, I was going to get to that because, as a matter of fact, there is no community control violation writing here. And second to that, my client was never served. So the state says, well, wait a minute, she was served in the jail. There's no evidence of that. The sergeant at the jail was served. And so when you take a look at a drug addict...
You mean there's no evidence that this record right now did not include anything from the sheriff saying that there was service done or anything as part of the record showing how service was made?
There's not only
The
no...
record being the document journal entry, not what was testified to.
Well, Your Honor, there's not only no evidence of service, there's no evidence, period. The state presented no evidence, presented no exhibits. There's no evidence that she received the rules. We don't even know what the rules are. So let's circle back to what we were talking about giving notice. Don't get none. Now, most of my cases, my client gets a community control violation letter. Same thing in the United States District Court. There's a revocation filed by the probation officer. So it tells what the violation is. But more importantly, it tells what you did to violate. So that is very critical, especially when you have a drug addict, especially when you have somebody that's not very smart. And more importantly, if you look at the cases that this court sets out itself, then it is clear that the process has never been followed. So we have no service of what she did. The record doesn't contain any allegations as to what she did. And, Your Honor, Judge Stevens, your point is a good one. Because in general it says, well, she used drugs, and she admitted to using drugs. And the important thing about that is, and by the way, the state concedes that my client was never served. The important thing about...
I don't think that's true. I think the state says that service is proper by giving it to the sheriff who's running the jail when she's in jail. I don't think they concede she was never served. They concede that is the appropriate service for her. Not that someone has to go in the jail, walk around and find her and give it to her. So I would not agree with you that they concede that.
Well, I think they concede it when they say that Lacy was not served, and then they have no authority to provide for service when the rule they cite says very clearly you have to serve the individual. I mean, that's basic 101, Your Honor. The person has to be served with summons, served with plate, served with, in this situation, a CCV. And so when you're looking at the record and you look at the process, take a look at the preliminary hearing. There is no mention in the statement by the court what her potential sanction is. So the state said, well, we're going to go back. She was there at sentencing, so she knows what the sanction is. Could be 36 months. How do we know that? And so if there's an allocution coming from the defense lawyer who says, oh, well, by the way, she's a junkie, she relapsed, she was afraid to go because she has pending charges in another jurisdiction, we'll talk about ineffective assistance in a paragraph this lawyer, and not here to disparage this lawyer, but I am here to say, look, if you have a relapse, then maybe you ought to talk about it. Maybe you should have a hearing. Maybe you should see why she was afraid. Oh, and by the way, there's no new law violations alleged in this case, but yet they're talking about it at hearing. That's a little confusing to me. How does the lawyer get that in? When the lawyer herself brings it up, there's no new law violation.
Well, the state's saying they're not new since she was convicted, but she was charged with these offenses, drug offenses, prior to this case. And they're alleging that your client herself brought it up by saying, well, Judge, you know, I have holding out of Stark County or something. I'd like to get that resolved.
Yes, and that might be the time the lawyer jumps up and said, now Lacy, this isn't for today, especially when there's no evidence of these other charges. Lacy was unclear with it, but...
Well, I was wondering when I was reading that, they talked about her having 7 other pending cases. If that did enter into the trial court's mind and say, well, you know, she's going to be in prison anyway. You can't have her community control here, and then she has 7 other pending cases. They're not going to give her community control there as well from the fact that she's already on a community control violation.
I can adhere to that thinking, Judge Carr, but for the fact that we don't know anything about those cases, not being even referenced in any complaint or summons relative to those new cases, and more importantly, there's no evidence as to the process or where the standing is. When you have a community control violation, you don't bring in all of these other points of evidence. That's not the factual basis for her violation. The charge, if it were to be made, and it could be as you provided. But when you're not knowing the potential consequences, I mean, who's going to think you're going to get resentenced? You know, that your sentence is going to be reimposed after 3 weeks out. And I think that was also part of it. But look as well to how the state presented their case, even after the admission was made. So I don't think Lacy knowingly made an admission. The process wasn't appropriate because all of her rights were not defined, her exposure was not defined, her potential penalty was not defined. The state presented no argument, nothing. They said nothing. The state's not even here today. Obviously, they don't think this is important. So the procedural safeguards and due process is right, you know, that needs to be done according to rule. And that's why it's important for this court to say we can't minimize community control proceedings. And the reason that is so important is demonstrated right here with what happened with Lacy.
Counsel, I want to make sure I understand with, when she appeared and she ended up pleading guilty, the court, when it entered its order, said that a hearing was held pursuant to 32.2, and defendant was present and represented by counsel, was given an opportunity to speak and to present evidence, and so afforded all rights pursuant to Criminal Rule 32. And you're saying the transcript is going to demonstrate that's just not true.
Well, that was said in the judgment entry, right? But it was not
That's
said.
what I'm saying. The court said that in the judgment entry, but that's not what happened.
That's not what the record demonstrates. And that's why scrutinizing the record is so important here, because if we get away from procedural safeguards, what's the difference if it's a plea to the indictment or if it's a revocation hearing? When you're facing 2 years, which is 3 years she was facing, the judge did give her a little break, but there's no factual basis, and that's what State v. Phillips requires. And I'm circling back to a conclusion here to say, if you can find in the record what Lacy did, then let me know in your opinion, because it does not say it. You can't, if you look at the thread, so Exhibit A in the judgment entry does not have any rule violations. There's no evidence of any rule violations in the record, number 5 and 6. I don't know what those are. So leading now to foundation, what's the foundation for this sentence? How about a sanction? And if you're in treatment, shouldn't again, the lawyer have had a hearing telling the judge, look, my client's sick. She suffers from the disease of addiction. It's not something we want to blow off because addiction is real. As a practitioner, I deal in my criminal practice, I deal with it every day. And that reality, we can see it all the time. I mean, so is rehabilitation in prison, is that the answer? Or is rehabilitation, give this woman an opportunity to do her probation, not just 3 weeks later?
Counsel, are you saying that your client did not knowingly, intelligently, and voluntarily enter a plea of guilty?
Yes, Your Honor, most definitely I'm saying that. And there's nothing in the record that can give foundation to that. We don't know what she did. This is a drug addict. The CC revocation hearing was simply unfair according to this court's rulings, this court's rules. Did Lacy know what she was doing? No, we don't know that because that's what's wrong here. And I would conclude by saying 21 days of community control should not equal to 24 months. A sanctioned step down maybe, but in this case, the court abuses discretion, and it was just unfair. I know we do that a lot, but it's imperative upon this court to tell trial courts, let's not just blow off community control violations. Let's give due process.
Thank you very much, counsel, for your presentation. We will take this matter under advisement and issue a decision to you in due course. The clerk of court will mail a copy of the decision to you as well as to the opposing counsel on the day that it's released, and the opinions will be posted on the Ohio Supreme Court website. And again, thank you very much for your presentation.
Thank you, Your Honors. Thank you for hearing this case on behalf of Lacy.